Welcome to this episode of TaxSnax with me, Harriet Brown. I am a barrister and Jersey advocate at Old Square Tax Chambers, and I am talking about, over this and a couple of other episodes, some really interesting cases that have come out over the summer, and the first one of those is Trachtenberg and HMRC. So this was a judgment of the Upper Tribunal, and it was published on the 26th of June, so you may already have come across it. And it was a case about pension taxation. Well, it was a case about what procedural rules apply to pension taxation. So, it looks at the way that Finance Act 2004 sections 208 and 209 interact with the procedural provisions in the Taxes Management Act, specifically section 29, which, for those of you who don't know, is HMRC's power to make a discovery assessment. So, the first thing to notice about this appeal, which is pretty interesting, is that it involves two long since past tax years. The first one is 2006-7 and the second 2009-10. And essentially it just turns on statutory construction. But it involves two quite significant charges, and these are charges on unauthorised payments made from pensions. You can find them in section 208 and 209 of the Finance Act 2004, and in essence, section 208 applies a 40% charge, and section 209 a 15% surcharge. So we're talking about relatively significant taxation here. What is pertinent for these purposes is that both of those sections describe the charge and surcharge respectively as a charge to income tax. So I'm not going to take you through reams of legislation, but the important words in those provisions is to remember is that both the charge and the surcharge are charges to income tax. Now, in relation to tax year 09-10, the Income Tax Act 2007 said that income tax is charged under Chapter 5 of Part 4 of Finance Act 2004. So that further tells us that we have income tax being charged at this point. Section 23 of the Income Tax Act calculates income tax and tells you that you have to add what's referred to as a Section 30 amount. Section 30 amounts include amounts chargeable under sections 208 and 209. So that's the structure of the legislation that was in question. It's a bit of a gallop through, but it's not desperately complicated. And the taxpayer, Mr. Trachtenberg, argued that section 29, Taxes Management Act 1970, didn't actually allow the recovery of any amounts chargeable under sections 208 and 209. Now, what that means is that if the taxpayer arguments were correct, this would mean that those provisions, those charges assessed under those provisions, could never be taxed by way of discovery. So there were a couple of other points, but that's the main point that we're going to focus on because that's the one that I think is interesting. The first tier tribunal had found for HMRC, and that was appealed, but on the first point only, i.e. this whether or not section 29 applies point. So, in the judgment, paragraphs 18 and 19 set out the arguments that were made before the first tier tribunal. And essentially, what was said was that any charges arising under 208 and 209 didn't fall within any of the three situations in respect of which an assessment was permitted under section 29(1), and that the only potentially relevant situation was section 29(1)(b), which refers to a discovery by HMRC that an assessment to tax is or has become insufficient. And what was argued for the taxpayer was that 208 and 209 were freestanding charges which applied to payments rather than years of assessment, and the section 29 reference to assessment being for a year of assessment meant that those charges fell outside of section 29. And he also said that the surcharge and the charge could not be self-assessed, so they couldn't form part of a self-assessment tax form. So the first tier had said that Mr. Trachtenberg, having completed self-assessment returns for the years in question, could only be insufficient if the Section 208 or 209 charges were required to be included in that self-assessment return, but the FTT dismissed the taxpayer's arguments on that point. And one of the things that the FTT actually said was that that analysis was consistent with the purpose of the unauthorised payment regime in Finance Act 2004. Another argument put by the taxpayer, no, I'm not going to go into that now. Let's look at the Section 209 arguments, which were that a Section 209 charge could not be included in a self-assessment return because taking into account that a taxpayer could apply in the same return for such a charge to be removed under Section 268 Finance Act 2004. So to pause there, you have a situation where the FTT you have a situation there where a Section 209 charge is being said to not be something that can be declared in a self-assessment return, but in a return you can ask using Section 268 for such a charge to be removed. And the first tier felt that it was clear from the legislation that the charge arises when a relevant payment is made and the liability continues to exist unless and until relief is granted. And on that basis, they found that Section 208 and 209 could be and should be included in a self-assessment return. So when this went to the upper tribunal, Mr. Trachtenberg argued the following, which was that Section 29 couldn't be used to assess the charges otherwise than under regulations made under Section 255 Finance Act 2004. That was their first point on appeal. And secondly, that Section 29 does not cover the charges as they are not tied to any year of assessment and cannot be self-assessed. So those were the 2 points on appeal. And I suspect you can guess what I'm going to say, which is that neither was successful. But shall we look at why neither was successful? So in relation to the Section 255 argument, the key points were the following. Provisions in relation to unauthorised payments form part of a comprehensive and prescriptive pension schemes code, which was introduced in Finance Act 2004. Contrary to the First Tier Tribunal's conclusion, Taxes Management Act alone would not enable charges to be assessed under the code in absence of any express application by Section 255 or regulations under it. The second point was that this was illustrated by examples, i.e. that the code in FA 2004 is a standalone self-contained code, and the taxpayer pointed to sections 149 and 252 to support that, and then said that that position was put beyond doubt by section 255 3b, which states that regulations under section 255 may provide for the application of any provision of the tax acts with or without modification. And it was argued that that wording wouldn't have been needed if section 29 TMA did apply independently of the Finance Act 2004 regime. Now, they said, look, HMRC may have believed that there was no need for assessment regulations under section 255 because they thought section 29 applied, but they were wrong. Parliament had left it to HMRC to implement the necessary regulations, and HMRC just hadn't managed to do that. So those were the reasons. As I've already mentioned, they were not successful. So the first reason they weren't successful was because the power to make regulations is discretionary, i.e. it's may make regulations, may by regulations make provision for. So they said, look, that's discretionary, it's not mandatory. If the drafter had intended the provisions to be an exclusive and self-contained code with no provisions as to collection and assessment in the primary legislation, it is very likely that they would have specifically addressed such a fundamental feature of the code rather than simply including permissive powers. That seems to make sense. The point about the examples of the code being self-contained were also rejected as being materially outweighed by the absence of any clear statutory language to support such a reading. Thirdly, in relation to section 2553b, they said the natural implication was that certain other provisions are operative for the purposes of the code, as otherwise there would be no need for a provision to be made by regulations modifying them. So that was the upper tribunal's third reason for refusing the appeal. Their fourth reason was that they looked at the explanatory notes to the Finance Bill 2004, and these said, Clause 2416 gives the Inland Revenue a regulation-making power in respect of making assessments of the income tax the scheme administrator is liable for, in which they must make a quarterly return of to the Inland Revenue. The Inland Revenue will also need to have power to raise other assessments in connection with payments of income tax due under this part. For example, the scheme administrator is assessable in respect of the scheme sanction charge under Clause 228, which is excluded from Clause 241. The recipient of a relevant lump sum death benefit may be chargeable to the lifetime allowance charge. The detail of the note is not material, but we consider that it indicates that Section 255 could have had another much more limited purpose than that suggested by Mr. Gordon. Their final point was that if the arguments of the taxpayer were correct, HMRC couldn't and had never been able to assess charges imposed on individuals under Sections 208 and 209, rendering the legislation unworkable. And they referred to the speech of Lord Dunedin in Witney and Inland Revenue Commissioners, saying that where possible the interpretation of legislation should be to secure a workable result in a case where Parliament had clearly imposed a liability. And so for those reasons the primary submission was rejected. Turning to the second submission on behalf of the taxpayer, this was the idea that Section 29 TMA could only charge the provisions if the charge was for a year, and Sections 208 and 209 weren't for a year. The tribunal dealt with this in shorter terms, if I can put it that way. And they said, look, we accept that income tax is an annual tax, and it applies by reference to years of assessment, and that Section 29 does say that it applies as regards the year of assessment. What they disagreed with was the idea that charges arising under Section 208 and 209 were not charges for a year of assessment, and that such charges are not required to be included in a self-assessment return. Now, if those 2 points were correct, then there would have been no way within Section 29(1)b, because there would have been no insufficiency in the return which the taxpayer had submitted to HMRC, and in relation to which HMRC said they made a discovery. So the assessment in the appeal would simply have been invalid. Also, if they were correct, the consequence would logically apply to any discovery assessment made by HMRC under Section 29(1)b in respect of a charge on an individual under 208 and 209, and that would have always been the case since those provisions came into force. So what the tribunal was outlining there was that there were very serious consequences of that analysis by the taxpayer. So they then went on to look at the principles of statutory construction, and they referred to the pretty recent Court of Appeal case, HMRC and Innovative Bytes Limited, which sets out some of the principles. That case itself referred to Black Clawson and to Project for the Registration of Children as British Citizens, Project Blue and other cases, including Rossendale Borough Council and Barclays Mercantile and Arrowtown. So they went through all of those cases, which I'm not going to go through now, all important cases. But they said the principles in those cases were important to interpreting the provision here. So, they said they agreed with the FTT to the extent that the purpose of the unauthorised payment regime was to deter people from accessing their pension funds other than in circumstances permitted by the pensions regime, and pointed out that one of the main ways that was achieved was by imposing a charge to income tax on certain payments. They also noted that the purposes of Sections 8 and 9 of the Taxes Management Act is to oblige taxpayers to make a self-assessment return which assesses amounts in which the person making the return is chargeable to income tax and capital gains tax for the year of assessment. They summed up the taxpayer's case like this. They said, look, Sections 208 and 209 does not result in amount which is chargeable to income tax for a particular year of assessment. And they fundamentally disagreed with this. They set out some quite detailed reasoning from paragraph 49 of the judgment, which I'm not going to go into in detail, but at paragraph 54, the upper tribunal said this: far more explicit wording would be required to exclude charges under sections 208 and 209 from the obligation to be included in a self-assessment return. So clearly what they're saying there is, yes, we can see that this is not wholly clear, but to prevent these things being chargeable in the way contended for by the taxpayer, that would result quite clearly in an unworkable situation. And so on that basis, the taxpayer's argument was rejected. So it might be said that this is a relatively straightforward procedural case, but it is one that's maybe, even going to the upper tribunal, has gone further than one might have at first thought. So look out for any appeals on that. It'll be interesting to see if it goes any further. Thank you for watching.